Hi, good morning, everybody. My name is Jessie Weber. I'm a lawyer at Brown, Goldstein, and Levy in Baltimore, Maryland. I probably didn't need to say I was a lawyer because I realized as soon as I packed my clothes that there probably wouldn't be many suits here. So but I stuck with it. I see there's another suit jacket, 'cause I thought it was important to play the role of a lawyer at this conference. So good morning. Sorry, as you can hear, I'm fighting a cold. I'm at the tail end. So hopefully my voice will keep up. But it's really nice to be here. So I'll be presenting the 2024 legal update this morning, following in some big footsteps of Lainey Feingold and my colleague Eve Hill. I'm hoping to make it somewhat interactive, and so I'll have times when I open things up for questions and or proposed answers. And if you all have questions, feel free to interrupt. We don't have to wait till the end. I'm fine to kind of make this more of a conversation and answer what people are thinking about. So let's see. Hopefully this will work. Yes. Okay. So just so everyone knows what to expect, we'll talk a little bit about this is an update on digital accessibility, so we'll talk a little bit about what that means, make sure we're on the same page. Then we'll dive into the federal laws, the regulations, the guidance that governs this space, state laws, international law, things that are on the horizon, case updates, and then some best practices for how to have organizations comply. And so I guess just so I kind of have a sense, it's my first time here, so I know the audience. I know a lot of you guys are kind of digital accessibility experts. Just by show of hands, how many folks here would kind of consider themselves, fully, deeply in the space of digital accessibility? Okay, so most of you. And how many people are here to kind of learn more and are kind of beginning their journey? Okay, great, awesome. So, all right, so this is fair game. So I will, I'll ask these questions, even though I know a lot of folks probably are fully aware of all of the various answers. So. When you think of digital accessibility, what do you think of? And does it work to have people call things out for captioning and interpretation? If not, I won't do it. Okay, I can repeat it. Okay. So what comes to mind when you think of digital accessibility? Websites.
Equitable content.
Equitable content, great. Anything other than websites?
Civil rights.
Civil rights, I love that one. Kiosks, great. Mobile apps, yep. Anything else? Documents, Content management systems. Good, okay. Anything else? ATMs, yeah, great. I think of that kind of in the kiosk space, but it was sort of like the first of the accessible kiosks. Okay, yeah, so a lot of, at least legally, we've been focused on websites, and I think that's starting to change. So we've heard mobile apps, software programs. I know, for example, like electronic health record systems is a big deal. Student content learning management program software, registration software, kiosks. Virtual reality is a new one, and there are some cases we'll talk about that have dived into that. And then there's kind of what is the standard we're talking about. So we heard equitable content, which is great, and civil right. There's sort of the industry standard of WCAG, the Web Content Accessibility Guidelines, or at least, as a lawyer, I'm not in the industry, but that's my understanding. And then there's sort of like the functional goal, which is often written into Department of Justice settlement agreements. I know I've had in some of my settlement agreements that the goal is really to allow people with disabilities to access the same information, engage in the same transactions, the same time, with equivalent ease of use as everybody else. So that's kind of what we're looking for. And I think some of, and I know this conference focuses on usability as well, and I've certainly had cases where people design to kind of meet sort of technical specifications, but still end up with a completely unusable product. So I like kind of having this broader language here to kind of keep us functionally, have the functional end goal in mind as we're designing or talking about redesigning. So when we're talking about people with individuals that we're designing to include, so certainly people who are blind or have low vision come to mind. A lot of my work is on behalf of the National Federation of the Blind, so that tends to be a lot of my focus. But also, certainly, we're thinking about people who are deaf, have hearing loss, who need captioning or sign interpretation, people with dexterity impairments who are not using a mouse, who might have limited keyboard functionality, and then as well people with cognitive disabilities, learning, reading impairments. So I know, for example, people with dyslexia are big users of screen readers. So when we talk also about digital accessibility in terms of kind of when we get into the nuts and bolts, a lot of it comes down to coding, to work with assistive technology, and to work for people with disabilities. And I feel like I don't need to kind of share this list with this audience because this is what you all are doing. But these are kind of the common things, at least in the legal space, that come up in cases in terms of what are the features that are missing, what is kind of not working to make these websites or other types of technology accessible. So alt text for images lacking is a big deal. Unlabeled form fields comes up a lot. And I won't read the whole list, but these are all examples. So why are we talking about digital accessibility, other than this being a conference about that? Why do we care about it? So I heard someone said civil rights. What other kind of interests come to mind that make us want to care about this topic? Anyone? Mm-hmm. Yeah, so we heard economic benefits for an organization, getting customers, workload issues. Anything else? Inclusive work environments, great. Yeah. Yeah, access to information with everything being online, banks paying bills. Yeah, over there.
As far as like disability rights and essentially the history of civil rights in this country and access to physical spaces as well as digital spaces is equitable.
Yeah, so in the context of civil rights in the country, access to both physical and digital spaces is being an equity issue. Yeah, so you guys hit a lot of the topics I have. So I see it as number one, an ethical issue. I think someone mentioned just kind of leaving people behind. We have this increasingly digital world, and when we don't design for people with disabilities, we're really just saying we don't care about bringing you into this new space, and we're shutting people out. And I see that as a matter of ethics. We heard about inclusive workplaces, so I see it as a DEI issue as well. And I think sometimes too, with people with disabilities are left out of DEI conversations, unfortunately, and it's so critical that we include folks with disabilities, especially because I do think a lot of the DEI discussion has been about not just including people for the sake of being fair or being nice, but because we get benefit, we get value, and everyone is at the table, and we hear all ideas and all voices. And so when we're shutting people out, if we don't have people who are blind in our workplace because we have inaccessible technology, we're missing out on valuable contributions. If deaf people can't listen to podcasts because there's no captioning, they miss out on kind of all of the ideas. They can't contribute fully to our marketplace of ideas, and so inclusion is a really important part of it. I'll also just flag security and privacy. So we hear a lot about concerns about digital privacy and making sure websites are secure. I know I've done work in the voting space, and this comes up a lot. We don't want to make allow people to mark their ballots using an online tool because someone could be spying on them from afar. And those are all important concerns, but I think what gets left out is that if something is inaccessible and someone has to rely on third-party assistance, then it's not a risk of their security and privacy being invaded. It's 100% happening. So if I have a paper ballot and I need someone to fill it out for me, then 100% my privacy and of my vote has been invaded. So we need to be thinking about kind of what the alternative is when something is not made accessible in terms of security and privacy. And there's a picture here in the top right of an ominous-looking cartoon figure looking with a magnifying glass at someone on their computer. The other part, and this was mentioned as well, is it's good business, right? I assume businesses don't want to turn away customers for no good reason, but that's exactly what businesses are doing when they fail to make their digital technology accessible. And there's a picture of someone turning away a wad of cash. And then finally, and this was brought up earlier, and this is my favorite one, it is a civil right. So in this picture is a picture of folks with disabilities climbing up the steps of the Capitol to protest for regulations for people with disabilities to enact the Rehab Act. Really, the digital space has become, because it's such a prevalent part of our society, it's become part of civil society. Exclusion from that means that you're lacking a civil right. You have a civil right to be able to participate in the expansion of our civil society into the digital space. Or as, there's the legal scholar Jacobus Tenbrook, who was blind, put it, there's the right to live in the world as a person with a disability. And I think that really ties into this conversation, this area being a civil right. Yeah.
Really quick, there are 22 participants on Zoom online, and they are requesting that if anybody has questions, that the mic can be brought.
Oh, okay.
So just raise your hand and give her a second to get to you because they want to hear what y'all are asking.
Great.
Also, do you mind lifting your mic up just
Oh, yeah.
so somebody says they hear promptly?
Okay.
And I will adjust the volume on mine.
Thank you. All right. So it is a civil right, and we're falling short, unfortunately. So there are about 1 billion websites growing every day. There are about 200 million active websites, and this is all according to WebAIM's latest report. And unfortunately, the top million websites, of those, 95% have accessibility barriers. The number has been falling over the years, but it still hasn't gotten below 95%, which is, of course, disappointing. The average errors per page have increased over the past year, which is bad news, but there is a silver lining here, which is that the number of pages with fewer errors has increased. At the same time, the number of pages with a lot of errors has also increased. So what this tells us is that the organizations that are focusing on accessibility, on making their websites accessible, are doing a better job, right? Because their pages are having fewer errors. The organizations that are ignoring the issue, their websites are getting worse. So it's a silver lining in terms of those focusing on this. It's not an impossible task. It's not an impossible feat. They are able to make their pages more and more accessible, which is good. So let's dive into the laws, which is why you all came here, not for me to tell you about digital accessibility. So we'll talk about the federal laws, the Americans with Disabilities Act, the Rehabilitation Act, specifically sections 504 and 508, the Air Carrier Access Act, and the Affordable Care Act. And then I'll talk a little bit about some state laws and international laws as well. Caveat, though, that I don't really practice in the international law space, so I don't have too much knowledge, but I have a little bit, but I probably can't go too deep there with the questions. So let's start with Title I of the ADA. So, yeah.
Can you ask her to move that settings screen off so we can see the slide? Thank you so much. Sorry.
Okay, thanks. So Title I of the ADA, so the ADA is divided into 3 titles. Title I covers employment, and we'll talk about the other 2 in a bit. So Title I applies to private employers. They just have to have 15 or more employees for it to kick in. And it covers all aspects of employment, from the hiring process, applications, testing, promotions, termination, compensation, training, benefits, all the privileges of employment. So the statute talks about the need for providing reasonable accommodations and further describes the types of discrimination that are prohibited. There's a lot of types that are spelled out in the statute, but I want to call attention to the parts that specifically address qualification standards, that are such as employment tests, or anything used to kind of screen out people with disabilities at the front end. So this could be, for example, if you have, if an employer call center, for example, is using inaccessible technology and requires all the employees to use that, one could argue, and they say, we're not going to hire this person with a disability who can't use our software because this is what we have in place. One could argue that that is a qualification standard that has the effect of screening out people with disabilities and would violate the ADA. I will tell you, this is an area that I think is developing because it's a little bit unclear whether the reasonable accommodation standard kicks in which case the employer says, well, at this point, it's really expensive for us to kind of switch systems or to try to, have some patch to make it accessible. And so, we win. It's an undue hardship versus thinking about it as, well, it's actually a discriminatory qualification standard, something used to screen people out, in which case you don't really get into the interactive reasonable accommodation process. So this is an area I think we'll see more development in, and hopefully the EOC taking a good role in providing clarity on the law here. The other thing I'll just note, there's no technical accessibility standard, so it's really kind of what works for it's very individualized in this space, what works for the employee. And here as well, I think for employers, given that there is uncertainty and that I think there's a good argument that having inaccessible technology can be viewed as a discriminatory qualification standard, and this is probably no surprise for this group, but it's important to kind of, at the moment of procurement, when you're implementing the new technology, to make sure it's accessible, because as you all know, it gets much more costly then to try to remediate after the fact when you suddenly have a blind applicant coming to your place of employment. So Title II of the ADA, this title applies to state and local governmental entities, public entities. This is my favorite title of the ADA, and I'll talk about why. So Title II covers basically any program, service, or activity offered by a public entity. And the Department of Justice and their regulations have said it applies to basically anything a public entity does. So don't get tripped up by service, program, activity. It's everything they do. And just for the non-lawyers, which I think you might all be non-lawyers, a regulation is an agency's interpretation of a statute. So Congress passes the statute, that's the law, the agency interprets. A regulation is taken quite seriously by the courts. It's given a lot of deference because the agency has to go through a notice and comment period where they give the public notice, advance notice of proposed rulemaking. The public gets to say all the, what they think about it, and the agency has to respond and show that they kind of gave reasonable attention to each comment in issuing the final rule. So there's a lot of thought that goes into it, a lot of process. So it does get quite a bit of deference, particularly the Title II regs, because they're based on regs that were around at the time the ADA was passed. So one thing to note here, and don't worry, I know you're all excited to talk about the new Title II regs, and I'll get to that. But just as background, the Department of Justice has consistently interpreted the ADA to apply to websites operated by public entities, and said that they have to do it accessibly. So there's nothing new there. And on the bottom of the slide is the text from the statute. No person with a disability can be basically excluded from participation, be denied the benefits of the services, programs, or activities of a public entity, or be subjected to discrimination. So it's pretty broad. So that gets us to the regulations, which really kind of give meat to what that means. What does it mean to kind of just generally otherwise discriminate? So the regulations, yeah.
Can you just give us a definition like public entity?
Yeah.
Hang on,
Oh.
say that again. I was gonna say, she can't repeat it, right? Just so we're on the same page, can you give us a definition of a public entity?
Yeah. So a public entity is any state or local governmental entity. So it can be a city, it could be a state itself, and it could be any body they control. So for example, a school would be covered because it's controlled by the local government. Prisons are often covered. It could be a hospital. I had a case recently against the University of North Carolina healthcare system, UNC Health, and that is a state-controlled hospital system, so they are also covered by Title II. So generally, kind of any public entity is not federal, so that we'll talk about is different, but anything that kind of has government operation at the state or local level will be covered. It's fairly expansive. Yeah.
Really quick question. Does it also cover an entity that just receives state money, or does it have to be controlled fully by the state?
Yeah, good question. So if it's a private entity that receives state funding, that private entity doesn't become subject to Title II itself. Now, there might be contractual provisions that say, here's what we have to do, you have to do this too. And so if they don't do it, they might be liable as a matter of contract for violating the contract, but they wouldn't be liable under Title II of the ADA. However, the public entity that contracts with a private entity to provide services on behalf of the public entity. So for example, if I'm just going to pick on them because I just had a case against them. If I'm UNC Health and I contract with a private medical group and I say, you know, we're going to give you money, give you space in our building, and you're going to provide services to these patients, that private group doesn't become subject to Title II, but UNC is still on the hook if that private group discriminates, because you can't contract away your obligation to comply with civil rights laws. So contracting obligations away to private entities doesn't alleviate your legal responsibility under Title II, but it doesn't make that private entity, doesn't put them on the hook under Title II, if that makes sense. Okay. The regulations here are quite powerful, and this is why Title II is my favorite of all the laws. So they mandate really nothing short of equal opportunity and equally effective communication. And I have some of the language here, and my favorite parts of the language bolded. So you can't provide an opportunity that's not equal to that afforded others. The benefit has to be as effective and affording equal opportunity, get the same result, the same level of achievement. So that's a really strong mandate. It's really powerful. And then there's the effective communication portion. So the communication you provide with people with disabilities, to people with disabilities, has to be as effective as communication with others. So that's how we get, the as effective gets me to equally effective. And then the regulation goes on to specify that to be effective, auxiliary aids and services have to be provided in accessible formats. It has to be in a timely manner, which you know, one might say should be assumed, right? If you're providing communications in a timely manner to everybody else, then to be equally effective, they need to be provided timely to people with disabilities, but it's not always the case that entities see their obligation that way, so it's nice that it's spelled out here. And in such a way as to protect the privacy and independence of the individual with a disability. And this part's important because there is some guidance that the DOJ put out previously about the role of qualified readers or scribes. And that certainly can play a role, and if that is what somebody wants as their auxiliary aid or service, that's fine, they're entitled to it. But what's important here is that it kind of, I think, gives people with disabilities more, gives more weight behind their request to have the auxiliary aid or service provided be one that allows them to do the thing privately and independently, right? So they can read it themselves, they can write it themselves, they're not relying on a third-party reader. And so that's really key. Yeah.
So my understanding is that if I post a PDF to a website, it should be accessible at the time that it's posted. Is that correct? Or does timely manner just mean very soon, as soon as you can make it so?
So in terms of the posting a PDF, whether it should be accessible, it kind of depends on the law. And we'll talk about, for Title II, soon it will be the case. I mean, I would argue now it should be accessible. But in terms of how quickly, I think timeliness, it's really in comparison to what everybody else is experiencing, right? So if everybody else goes on a website and, oh, there's a PDF and I can read it right away, I don't have to wait to a day to, you know, request access and then someone emails it to me, then I would argue timely, equally effective means I also have that instantaneous access. Now, if it's impossible, we know it's not impossible with PDFs, but if there's something else that it's impossible to get something right away, then it becomes kind of a balancing test of how quickly you can do it. But it's nice that timeliness is included here because courts need to be thinking about how quickly are you getting the document in comparison to everybody else. Was there another question? Yeah.
Hi, yes, about qualified readers you were just talking about. I have one. And I'm curious if having a qualified reader is a reasonable accommodation that means that my employer doesn't have to fix things.
So in the employment space, in Title I,
I'm sorry, this is a public university.
oh, public university. So there's a little bit of a mixed question about whether you'd probably be, I mean, you should be covered under Title II. Unfortunately, sometimes some courts look at employment under Title II and they look at what's happening in Title I, which is more of like a reasonable accommodation process. But if it's a public, my position, if I were your lawyer, is that Title II applies and it needs to be. So actually, let me get to the last part because I think that'll answer your question. A lot of it will come down to, so the public entity is obligated to give primary consideration to the requests of the individual with a disability. So if you are saying, hey, I don't want a reader, I want your software to work with a screen reader, that's what they need to do, unless they can prove there are some affirmative defenses, and we'll get into that. They can't say, well, we could do that, but that's kind of expensive. We'd rather provide you with a reader, which we think is less expensive, and will do the job. Because under Title II, again, it has to be equally effective, and I think there's a good argument that, assuming you want something other than a reader, that to be equally effective means that you get to do it on your own. You don't have to have someone kind of working with you. And again, they have to kind of give deference to primary consideration to the person's request. So that being said, if your request is to have a reader, then they have to give primary consideration to that request as well. And that's different. We'll talk about kind of in other, certainly different from Title I. It's not a primary consideration standard. It's this interactive process about reasonableness, and the employer and employee go back and forth, and we'll get to Title III in a second about public accommodations. But Title II really has the most, the strongest mandate, and it puts this kind of affirmative obligation on state and local entities to really affirmatively provide equally effective communication and be ready to respond to requests for all sorts of auxiliary aids and services, and to give primary consideration. So I hope that answers your question.
Thank you.
Sure.
Lainey says hi.
Oh, hi, Lainey. All right. Let's see. Whoops. Okay. So here's the exciting part everyone's been waiting for, I'm sure. So there's been a new development here. We have new regs that have finally come. So on April 9th, the Department of Justice finally issued its final rule governing the accessibility of web and mobile content by state and local public entities. As I'm sure many of you know, this rule is 14 years in the making. We've had lots of notices of proposed rulemakings, and we all got so excited, and then nothing happened, and then they were withdrawn, and then so it's been quite a ride. And the rule was published in the Federal Register on April 24th, becomes effective 60 days after that, which is June 24th. So June 24th, we'll have new web mobile content Title II regulations on the books effective. So very exciting. So the whole of it, in short, with very limited exceptions, the rule requires public entities to bring their web and mobile content into compliance with WCAG version 2.1, levels A, AA. Now, there are some differences in kind of the timeline for complying. So public entities with more than 50,000 people have 2 years to comply. So by June 24th, 2026, everything will be expected to be compliant with WCAG. Entities that are smaller or special district governments have 3 years. But existing obligations continue to apply. And as you've probably, if you've come to these updates before, courts have held that the effective communication requirements require websites to be accessible, and the DOJ has been requiring it for a long time. So it's not like entities can just sit back and wait the 2-3 years. Yeah, I see a question. Hold on 1 sec.
Jeff Klein. So I have a question on public entities. So if you look at like a state government, you know, there's many different departments or agencies. Does each one of those a public entity, or is it look at the umbrella organization, which would be the state government?
Yeah, so each one is considered a public entity subject to Title II in terms of kind of where liability kicks it, where you can say you're this department, you have an inaccessible website up, you're violating Title II of the ADA, it applies to you. It counts as a public entity. It doesn't really matter if it's separate from the state government or not. The part it comes into oh, are you talking about for counting the number of people, or?
Yes.
Oh, okay.
Yeah.
So if it's, I think that's a good question. I think you look at if it's a state department, you look at the population of the state. If it's for example, if it's a state-operated prison, you wouldn't be looking at, because there's no population. The population you look at, it's like census population, and they don't show census population for like, the area around the prison. It would have to be the state government, or if it's a locality, if it's a city, if it's the city's aquarium, you would look at the city population. Yeah.
I don't want to beat a dead horse. I'm Roger Damari. So for a community college, the people would not be the employees of the college. It would be what, the people in the district?
Who are counting?
I'm sorry?
Are you talking about in terms of counting to the number?
Right.
Oh, so it's not, if it's a community college and it's run by the county, let's say, it's the population of the county. So not people affiliated with the college, because you're looking at census numbers. So you'd look at, if it's an Austin City college, you look at the population of Austin, which I'm pretty sure is more than 50,000. No, it's 50,000 people in the population. So like the Austin Public Library, to the extent it's run by the city, it would be the population of Austin, not the people who work in the library or go to the library. You're looking at the municipality population. Yeah. And I'll also just add, the DOJ has a nice FAQ thing on its website, and there's a little bit more clarity around how you count the population on that as well. Yeah, I see another question.
Okay, so I'm not trying to belabor it, so I just want to make sure I understand clearly. So I know it says state and local government, so even if the local government, let's say you have a small rural Texas city that's less than 50,000, so they have the 3-year, they're not subjected to the fact that the state of Texas is so large, like they will look at them as separate government entities. So the state of Texas has 2 years to comply, but maybe, Oatmeal, Texas only has, 3 years to comply.
That's right. Yeah, if it's truly a separate entity, I mean, sometimes there's murky things with, like I know, like in Baltimore, I live in Baltimore, like, is there a police force? Is it operated by the city or the state? And so sometimes there's murky questions. And for those, you have to figure, there might be some dispute over, do you look at the state population or the city? But if it's really a separate entity, a separate government, then yeah, you would look at the smaller population for that town.
There is like a census document from 2022 that lists different government agencies by state. You can search for it.
Great, thank you. So the thing I want to emphasize, though, is that, as I said, existing obligations continue to apply. And one positive development, and I'll talk about a little bit more in the case notes, since issuing this final rule, the Department of Justice entered into a settlement agreement with the city of Virginia Beach. And that agreement covers their websites and mobile apps and gives them basically 1.5 years to fix things. Gives them 6 months to assess the current state of their websites and apps, and then 12 months from that date to get it all fixed. So under that agreement, that city can't wait the 2 or 3 years to fix everything. They have to fix things much sooner. So, yeah. Okay. How do you want to handle the Zoom questions?
Yeah, just in case y'all into 5 years.
Hello, can you hear me?
Yes.
My name is Gabby. Quick question. So say if you are a designer or developer and a client comes to you and they're looking to have their website redone or whatnot, and say that you bring to them the regulations and they're not willing to comply, who is responsible moving forward under this new ruling, or kind of like what would you approach that as? Both parties responsible? I know right now it's kind of clients can sign almost like a waiver that the agency is not responsible if they don't comply. Um, but kind of like, who does that fall on to? Is it the person that is making the website, or the people that are hosting it, or the client?
Yeah, so if it's a public entity and they're contracting with a third part, a private vendor to make their website, the public entity remains responsible through the whole process for ensuring that at the end result's accessible under Title II of the ADA. The private developer, unless they're obligated by contract to make the site accessible, will not be on the hook unless there is a state law that applies that's different. So some, for example, there are some state laws, and we'll get into this, that say if you're getting money from the government, it's kind of a mini 508, which we'll talk about, you have an obligation to make things accessible. So it might depend on the state law, it might depend on the contract, but under Title II, the private developer won't become responsible, but the state, the public entity remains responsible. So hopefully that answers your question.
Yes, thank you.
Okay, great. Happy to keep going unless there's other questions on the Zoom. I can't see them. All right, I'll keep going for now. Hopefully someone can let me know. There are exceptions under the new rule. So there are 5 primary exceptions, and I'll talk about each one a little bit. There is an exception for archived web content. So this is content that was created before the time for compliance came. So anytime before June 2026, basically, or 2027. Now, it's not that it's just created beforehand. It has to be really just used kind of for sort of archival purposes, for research, reference, record keeping, and it has to be in a specially designated area of the website. So it has to kind of, might say like archived content or content not in use, but it can't be sort of mixed in with the regular website. And it can't be changed at all. So the moment somebody goes in and says, oh, let me update this thing, or let me convert it to a different format, it's no longer archived content. It has to become accessible at that point. So that's the first exception. The second is pre-existing conventional documents, and this one is a big one, unfortunately. So we're talking about Word documents, PowerPoints, PDFs, spreadsheets that were available, again, before the date entities had to comply. But if they are still being used for something, so if there is a form hanging out and it's still a PDF form and it's not accessible, but it's still the form you need to apply for something, or it's still the document that gives you the schedule of when a library is open, if it's still relevant in some way, then it has to be accessible. This exception doesn't apply. And again, if it's updated at all after the date of compliance, then you need to make the whole thing accessible. I should add, too, for all of these exceptions, including the last 2, the exception doesn't mean the organization just gets to say, or the entity just gets to say, well, we have these inaccessible PDFs, and too bad if anybody wants to see them, like we've done our part. You still, the rest of the regulations and the rest and the law itself for Title II still apply. So entities still have to provide equally effective communication. So what that means is that if a blind individual comes along, for example, and says, this archived web content that's just for research, like I'm doing research and I want to see what the votes were in 1985, and I need to get access to this document, the public entity has to get that person access to the document. Now, it won't be instantaneous, and I think it would be hard to argue that they should be able to do it, in a moment's notice, but it still needs to be as timely as possible. So we'll talk about this later when we talk about best practices, but it really behooves organizations to have, to the extent that they're going to maintain documents under these exceptions, they need to have a plan in place for how to provide the timely access upon request, so that people aren't waiting weeks, they're not scrambling to find a vendor, they have something in place to get these documents to folks as needed. Yes.
So real quick, let's say that an organization is moving through a migration and they're going to move certain news articles, for instance, in their organization to an archive section. So images would break, right?
Mm-hmm.
And so if they have to go in and update URL links to those images, does that mean that the content then has to be updated to meet the accessibility standard?
Yeah, that's a good question. My sense is that if the content itself is not changing, if it's just kind of we're putting it in a different spot, that wouldn't trigger it. Especially because organizations are going to have to be now moving what's going to be archived content to the special designated archive section. So just moving it alone can't be what triggers, I don't think, the need to remediate it. Yes, I see another question in the back.
So would pre-existing document, what if there was a pre-existing document that got modified?
Mm-hmm.
Couple words, paragraph, is that no longer pre-existing? Does that count as a new document?
Yeah, well, I don't know if it counts as a new document, but it takes it out of the exception for sure. So then it has to become accessible. Right. Yep. Okay, so the third exception is limited third-party content. So this is something where the entity contracts for kind of having somebody else put content on their site or arranges for it affirmatively, such that they can control it in some way. So they can say, take this off, right? If the entity is doing that, then that content, even though it's completely controlled or they can't kind of make it accessible, has to be, counts sort of towards their compliance. So an example is if you have a calendar or a map widget that maybe you get from a third-party developer, and you can't go and code it differently to make it accessible, but you have opted, you've said, I want this on my website, please put it on my website, or paid for it to be on the website, you're responsible. So you have to kind of get it off your website or get the developer to fix it or find something else. So that is something that's shifted a little bit, I think, from some of the proposed rulemaking. It is a bit stricter. So the fact that something is made by a third party is not a get out of jail free pass. You still have to, if you're choosing to have it on your website, you need to make sure it's accessible. The fourth exception is individualized password protected documents. So you can think about like a bank statement, right? You have to like sign into your bank account and you get a statement. So as a person, as a sighted person who can read inaccessible documents, you know, my bank doesn't have to make sure that the PDF they send me or that I get when I log in is accessible. But that being said, as I mentioned with this one too, it's really important that entities have the plan in place to get the individualized password protected documents into accessible formats for people who need them. And probably here too, you know, and this is something I've worked on in cases with government entities like the IRS and Medicare. There needs to be a process in place to make sure people with disabilities can say, hey, I need all of my statements in large print, or I need accessible electronic documents, so that the agency can then plan ahead and, you know, at the same time everyone else is getting their documents, get them to that individual in the format they've requested. And then the fifth exception is about pre-existing social media posts. And similar to some of the other pre-existing ones, if you were posting on social media inaccessible stuff before the date of compliance, you don't have to go back and fix everything. But again, if someone requests access to, I see this post from a year ago and it's all in an image and there's no alt text and I have no idea what it is, tell me what it is, you have to have a way to timely get that information to folks upon request. Yeah, I see a question.
I just want to make sure that I understand this. The 5 exceptions are absolutes as long as there are no changes made to any of those electronic notions.
Yeah, I mean, they're
No
absolute.
safe harbor.
I'm not sure you mean.
Safe harbor provision here. In other words, any content from 2024 back is completely exempt from this.
No, not any content, right? So it has to meet the definition of archived.
Under one of these 5 exceptions.
If it does, but if it's still in use, if it's still relevant, so if it's a document about how the local board of elections works and it's still relevant, I would argue that's not archived. It then falls out of the pre-existing conventional document exception because it's something currently in use for current reference, or if it's a form for a benefit that you still have to use, it wouldn't fall within these exceptions.
Yeah, I get that. As far as I'm concerned, that doesn't come under one of those exceptions. As you just defined it, because in use means it's relevant to
Right.
whatever's being done at that point.
So if it's a document purely that's like not really in use, that's for research purposes, it's what we think of as archival. Yes, it can stay there forever as long as there are no changes. But again, the organization has to be ready to get that in an accessible format to people upon request pretty quickly. Yes.
Hi, I just wanted to check. So your top one says it's effective June 24th of 2024. But does that mean the compliance within 2 years starts from the date of April, or does it start from the date of June?
From the date of June. Okay. Yep. So it'll be June 2026 or 27.
Actually, the fact sheet says April.
Oh, does it?
Yeah, it says April 2026 or April 2027.
Thank you.
I don't know why.
That's
it doesn't
surprising.
make a lot of sense.
Okay, I stand corrected.
Yeah, but the
Because it
fact
becomes
sheet,
effective.
the fact sheet says April. Yeah.
Okay, thank you. There we go. Stand corrected.
Hi, my name is Amy Cole. I have a question about courts. So the state, say a state court has something like a ballot initiative, and it is, I've seen these, they are non-OCR'd pictures of court documents or rulings. And those pretty much are always relevant. I would kind of argue that.
Yep.
So are the courts themselves going to be held accountable for the documents that are needed for people like voters to look at things like legal language and ballot initiatives?
Yes, they should be. So especially if it's something new they're creating, right? As they create new content, it needs to be accessible. Now, an issue that does come up with state and local courts is that if they have like an electronic filing system, they can't necessarily control what lawyers like me are filing, right? Now, there's some controversy around this because the DOJ could have said, state and local court systems, you need to require private litigants to only file accessible documents. It doesn't say that. They're still responsible for, if there is somebody who needs an accessible version of something I filed inaccessibly, the state court system is responsible for getting it remediated and producing it. So some state court systems might choose to say, like, that's really expensive, that's hard for us to do. We're just going to require every private litigant and every public litigant, we're just going to say, if you use our system for filing, you have to only file accessible documents. But that's kind of a gray, tricky area with state courts. But no, if they're putting out their own documents, their own orders, I would say, opinions from the court, documents related to elections, those need to natively be accessible, I would argue.
Follow-up question from that.
Yep.
Who would come after a court?
Me. I would come after that.
And individuals.
So, yeah,
could,
so the Title II of the ADA has two basic enforcement mechanisms. There's a private right of action, which means any person, any organization with standing can sue. So if I am blind and I needed to see something or read something that the court put out and they didn't put out the document accessibly, I could sue under Title II. And the Department of Justice can come after them as well. So government or private entities. Yeah. So the rule also makes a nice point of kind of affirming what I like to call, that separate is not equal. So this is with regard to kind of conforming alternate versions of a website. Sometimes you can ask for kind of the accessible version of a website, and it's like a stripped down version. And you all, some of you are probably much more familiar than me with this, but WCAG kind of sets out guidelines for when you can use a conforming alternate version, and those are incorporated into the new Title II regs. So my sense is that it's pretty it's kind of strict in terms of the circumstances under which there's no way you can make the primary website accessible, that you get to use this conforming alternate version. But what's nice to see here, from my perspective, is the DOJ has expressed a lot of skepticism about whether that will ever provide equally effective communication and access. So the pressure is really on entities to make sure that their primary websites are accessible. Yes?
My name is Miranda Capra. Does the individualized password-protected documents honestly give my power company permission to not make an accessible power statement? Like
So
my
if-
power bill is
Right.
individualized and password protected.
So if you need it to be accessible, they have to get it to you accessibly. If you don't have a need for it to be accessible, then they don't. They can put out to sighted customers inaccessible documents. But my hope is that many will choose, again, do they really want two separate systems? Do they want a system for producing accessible PDF bills for people with disabilities and then inaccessible for everybody? I imagine that would be kind of expensive and complicated versus just having a new workflow or some kind of system just to make sure they're just putting out accessible documents, period. But yeah, no, that is what they're allowed to do. All right. I have a blog post kind of summarizing the new rule on our website that I've linked to here if you're interested in learning more. And again, the FAQs that the DOJ put out are very good and apparently help clarify some of the things that I got wrong. So definitely check that out. So I'm going to move on unless anyone has any questions about the Title II new web regs. Okay. So in addition to the existing requirements, continuing to apply now while we're waiting for till April 26 or 27, continuing to apply, even if an exception applies, that you still have to provide equal opportunity and equally effective communication. The affirmative defenses that entities can claim continue to apply as well. So these are the defenses of undue burden and fundamental alteration. Also just included in the new rule, but they already exist in the regulations as well. So I excerpted the text of the regulation here, bolding what I think are the most important parts. But the key takeaways are it is an uphill battle for a public entity to claim these defenses. They have the burden of proving it. So in legal matters, there's often like a burden shifting thing. If I'm a plaintiff bringing a case, I have a burden of proving what's called the prima facie case, that I was discriminated against, that you're a public entity, that the law applies, and you violated it. But then the burden shifts to the public entity, and they can say, hey, this was, it would have been a fundamental alteration and undue burden. So a fundamental alteration, these terms are often kind of like used interchangeably, I find, by defendants, but they're very different. Fundamental alteration is this would fundamentally alter the nature of the service activities. So example, in the voting spaces, you're asking for people with disabilities to have 5 votes instead of 1. Like that would be a fundamental alteration of how we vote. An undue burden is this is too expensive, it's too resource intensive, you'd have to have all the staff shifting from teaching to coding or something like that. Some other parts of this defense to claim it for a public entity, they have to have the head of the public entity or their designee make the decision and issue a written statement of reasons for it. And I will tell you, as someone who litigates in this space, public entities, I've never seen one do this. So it's, not to give a tip if you're working for a public entity, but if you're going to reach this conclusion, you might want to write it up and comply with the law. Otherwise, you're going to have a hard time claiming this affirmative defense. The other part is that you need to consider all the available resources, not just those budgeted for availability. Not just budgeted, for accessibility. Excuse me, my cold is fogging up my brain a little bit. An example is if you are, the state library, and you could budget $0 for accessibility, and then you can say, oh look, it's out of our budget to provide captioning, and you can't do that, right? You have to look at the entire budget of the whole library system. Sometimes there are questions of do you go up to the state or do you stop at the library, and that can be fact intensive. But you need to look at the entire budget. And the other part to remember is that this is not, you don't get to kind of throw your hands up in the air and do nothing if one of these defenses applies. You're still obligated to provide the next best way to ensure equal opportunity, equally effective communication. So, for example, if going to the reader example, if an entity is going to say this would be way too expensive to change our software, which it may or may not, depending on their overall resources, they can't say, so you're fired. They then have to say, so our proposal is to provide a reader. Our proposal is, you work on this part and you don't have to do this. So they have to come up with something else. Yes.
So one of the interesting things with the Title II is the final regulatory impact analysis that accompanied it actually has some pretty good numbers in it about what basically how they calculated the financial impact of this on public entities, right? My question is, if we look at that, for example, it has a whole section for public universities on this is what we expect a per course cost for remediating online courses, right? My question is, does that ever come into play in this discussion, right? So the question of whether something is or is not an undue burden, will we essentially, if we haven't invested what the FRIA says we would be expected, is that would undermine our claim of an undue burden, right?
Yeah, I would argue yes. So that's a great question. So generally, it's a factual analysis. So if the public university says this is too expensive, they would be expected to show some facts and support, right? Like, we got this quote and look how much it is, and this is our budget, and it would put us out of business or something like that. And then the other side can come back, the plaintiff side or the DOJ could say, here are our experts. No, they say it's not that expensive, or you're not looking at the entire budget you have. Often, you can have a dispute amongst experts about how expensive it is to remediate something, for example. But I like your idea. I mean, I think looking at, to the extent that there are kind of average figures accompanying the regulation, yeah, I think that's fair game to point to and say, look, even the DOJ did this robust analysis of cost and found generally on average it costs this much, not what you're saying, university. It probably wouldn't be a substitute for still kind of getting more individualized assessment for that particular case, but certainly something I would throw in the mix. Why not?
I'm looking at it more as an argument for my leadership that I make to my leadership
Yeah.
about what they should be planning to invest.
Yeah, for sure. I think that makes a lot of sense.
Can you repeat that?
Yeah, sorry. I'm just saying that I'm trying to figure out how compelling it is for me to use that as an argument for my leadership about what they should be expecting to invest.
Right.
Up to, I believe the thing said, up to 1% of our gross annual revenue should be fair game or something like that. But there's a lot of numbers in there. So.
Yeah, I think that makes a lot of sense, and it's something that could come into play, and certainly the DOJ guidance and discussion of cost is something courts will look at. So I think that makes good sense to bring up. Okay, so that's Title II. Unless there's any other questions about Title II, I'll dive into Title III. Okay, so Title III of the ADA covers public accommodations. There are 12 categories of private entities that are considered public accommodations listed here. I won't read it through everything, but it covers a lot, right? Hotels, restaurants, any kind of shopping store where you'd shop, a mall, a grocery store, service establishments. So sometimes people in my profession forget that law offices are covered by Title III, as are doctors' offices, museums, any kind of place of public congregation, homeless shelters, adoption agencies, etc. I'll ask a question to see who's been paying attention. So a zoo is covered here. If a zoo is run by a local government, does anyone know what would apply? Is it Title II or Title III? Title II, I heard. Yes, correct. So Title III is really just private entities. So even though there's often overlap, sometimes there's museums or convention centers that are run by state, local governments. Title II would apply, which from an advocate's perspective, we want, because Title II has stronger protections. Okay, so Title III has some similarities with Title II, but there are some important differences. So I'll focus on what I really like about Title III first, because this session is about what I like about the ADA, right? What I like about you wanted my opinions on. So Title III requires places of public accommodation to provide individuals with disabilities an equal opportunity to use and enjoy their programs and services. And it requires the public entities not discriminate on the basis of disability in the full and equal enjoyment of goods, services, facilities, privileges, etc., advantages. It goes on. Yeah.
Marie asks, if a state agency claims undue burden, will the DOJ look at the agency budget or the state budget as a whole? For universities, will they look at individual campuses or the university system?
Great question. So it could be the DOJ looking or the private litigant. So I am often, as someone who represents plaintiffs in these cases, looking broader, right? So if it's even if we're challenging, well, I'll give you an example. I just had a case against the Los Angeles Community College District. The people in the plaintiffs who represented were at one particular campus, and that college actually waived their undue burden defense, which is a whole other story. But had they asserted it, I would have argued that the whole district budget applies, not just this campus, because it is one organization at the end of the day. So in terms of a department of a local or an agency versus the whole government, and there is some good case law. It kind of varies by circuit, and we'll get into what that means. But there is some good case law about kind of looking broadly as high up as you can get at the larger state entity. I think it would be hard to say for sticking with the LA Community College District example, I don't think we could claim that the entire budget of Los Angeles as a city is what we're looking at, but certainly the whole college district is the right place to look. So hopefully that answers that Zoom question. So back to Title III. So I just want to focus again on this full and equal enjoyment language, because I think it's really important here. Because what it means is that it's not enough to kind of let people with disabilities in through the back door, get them some access some way, somehow. It really has to be access to kind of all of the benefits, all of the conveniences, everything that makes this service something that the business offers to everybody else. You can't kind of skimp on the details. So, so for example, where a business has, you can call to place an order, let's say for pizza, or you can do it online. There's a reason that the business offers online ordering, because it's convenient for people. They can do it any time of day from their home. They don't have to get on the phone and talk to somebody. And that convenience is something that people with disabilities have a right to as well under Title III. So the fact that you can order some way isn't enough. You need to have all the same options, which is quite a powerful mandate and something I find businesses don't often fully appreciate. So the statute provides examples of what this kind of discrimination means, but let me jump into the regulations, which give it a little more flavor. Whoops. So as with Title II, there are regulations here about communication. Effective communication is required. A difference here between Title II is that it doesn't say it needs to be as effective as with communication with people without disabilities. So it's not an equally effective communication mandate, but it needs to be effective. And here again, the DOJ has really spelled out what effective means, which I think is super important in this context where it's not, we don't have the equal language to play with. We can at least say, well, communication's not effective if you're not affording me privacy and independence. Communication's not effective if it's untimely. So we still have that guidance here, which is helpful. But there's also no primary consideration language. So if I go into a business and I say, I need documents in large print, hard copy, and they say, well, we're going to give you an electronic PDF that you can blow up or use screen magnification software on, and that should be as good. If it works for me, if it is in fact effective, but my preference is just to have the hard copy, I probably don't have a case here, right? I can't really insist on getting what I'm requesting the most. That being said, if the reason I'm asking for a hard copy is because looking at the document on a screen is not effective for me, it strains my eyes, I have light sensitivity, the formatting doesn't work when it's blown up, then it's not effective. So we can still argue under Title III about what it means for documents to be effective or access to be effective. The other note I'll make is that the Department of Justice will likely work on web accessibility regulations under Title III next, now that the Title II regulations are out. They haven't said that, but that's everyone's expectation. Yeah.
Question about the document. So if a person has a learning or cognitive disability and is unable to consume content digitally and needs a hard copy, would that still be an argument for them getting the hard copy?
Yeah, I mean, because at the end of the day, it still needs to be effective. So that person can say, looking at this on a screen is not effective. I can't do it. That's one thing I'll caution. Sometimes people, use the word, it's my preference, I prefer it this way. And it's important in these conversations to not be using that language, because then it sounds like, well, both are fine, but I prefer this. So I always, and actually in legal documents too, I always slash out the word preference. You want to use the word effective. This is not effective for me. This is effective, because that's what gets you the legal hook. Okay, so question. Are standalone websites and mobile apps that are not connected to a physical store covered under Title III of the ADA? What do people think? Uh-huh. Okay, so I heard some adamant yeses, and then I heard some it depends. And since this is a legal presentation, of course the answer is it depends. So you beat me to it. I believe that they are covered, and many courts agree with me, and I'll talk about, I think the DOJ agrees with me, but not every court does, unfortunately. So I've put up a map of the United States. This country is divided. We have, in the federal court system, there's district courts, which are the trial courts. Each state has at least one. Sometimes they have a couple. They're big. And then those courts are part of larger circuits. So there are circuits 1 through 11, and then the DC circuit, and then there's a federal circuit as well. Right now in Texas, we're in the 5th circuit. The 9th circuit's a really big one. You can see on the map, it includes California, Nevada, Oregon, Hawaii, Alaska, and then all the way on the East Coast, there's the 2nd circuit covering New York, Vermont, Connecticut. So, and I'll just add, the alt text for this image actually has everything listed, so you can follow along there. There is a split in the country, and I will we'll kind of dive into that right now, so bear with me. So one thing that is important is that every court agrees that websites and mobile apps can be covered if they're connected to a physical location. So this is an issue that came up, for example, in the Domino's Pizza case in the 9th Circuit that I ended up getting involved in, where the Domino's website is clearly connected to the Domino's stores. No question, those websites are covered. Every court in the country would have reached that same conclusion. And one of the first cases establishing this was out of California, the National Federation of the Blind versus Target, where the court clarified, the statute applies to services of a place of public accommodation. It doesn't have to be a service inside of that place of public accommodation. And so it kind of looked at the language of the statute and reached that conclusion. So the courts that say that websites are covered or mobile apps are covered if they're tied to a physical location are the 3rd Circuit, right? That's Pennsylvania, New Jersey, basically. 6th Circuit, 9th Circuit, 11th Circuits. Sometimes it's called the nexus test. So sometimes they want to see that the service provided on the mobile app or the website is connected to what's being offered in the physical location. So going back to the Domino's example, that's very clear, right? You can order pizza from both places. It's very connected. But if there were a store, if there was a physical location, and for some reason the service they provided online was completely different, nothing related to what was in the store, then you might argue there is no nexus. And of course, if there is no physical store, then there can't be a nexus. So the circuits that have adopted, excuse me, that standard, they've reasoned that the statute talks about places of public accommodation, and a place has to be a physical structure, and so for a service to be covered, it has to be attached to that place. But other circuits disagree and say that you don't have to be attached to a physical location to be covered under the ADA, under Title III. You still need the website or service, though, to be included under one of those 12 categories that we looked at before of public accommodations. So, for example, an online store, that's a retail store, that's clearly covered. An online dating app probably doesn't fall within one of those 12 categories. I mean, maybe you could argue it's a service like a doctor's office or a lawyer office or something, a matchmaker service. I don't know, but you could probably get creative about it. But you still need to think about those 12 categories. So the circuits that allow standalone websites to be covered are the First, Second, and Seventh Circuits. That covers the First and Second are like the Upper East Coast, New York to, Maine, I believe. And the reasoning is that even though sometimes the statute talks about places of public accommodation, some of the chapter titles talk just about public accommodations, period, prohibiting discrimination by public accommodations. And they're also just looking at the intent of the statute, right? It's supposed to have a broad remedial purpose. Our world is becoming increasingly online. It just doesn't make sense to limit the statute in this way. And they also think about kind of, there's a lot of services that you don't need to physically enter a building for. So for travel services, for example, yes, there might be a physical travel agency, but you never need to kind of go in. You can always call or communicate via email or something to kind of have their services, to have access to those services. So that was kind of one of the first cases. Car Parts out of the First Circuit talked about kind of the overlap with a travel service. And that sure, it's the Car Parts Distribution Center case. Car Parts Distribution Center versus Automotive Wholesalers Association of New England. That's a case from 1994, but it was one of the first to kind of expand. Public accommodations isn't just limited to what happens in the four corners of a building. Another case that gives a nice overview of the reasoning behind including online-only businesses is the Andrews versus Blick Art Materials case, and that was out of the Eastern District of New York, and it really dives into the purpose of the ADA, that kind of having this exception for online-only businesses would be a huge carve-out, especially given where we're headed as a society, and that the goal of the ADA was to make sure people with disabilities were included in mainstream civic life, and that's the point of Title III, right? For places of public accommodation, we're not excluding people with disabilities. And reading it this narrowly to carve out online-only businesses really is antithetical to that mission. And then it talks about kind of, the statutory text arguments. So hopefully the future DOJ regulations on Title III, in addition to providing sort of standards, will also provide some guidance here. Some big, I don't know if I'd call them hints, but kind of informally, not through regulations, but through other statements the DOJ has made, they do seem to, they have the position that Title III does apply to online-only businesses. So there was an amicus brief the DOJ submitted in a case in 2000 with a subheading, a commercial business providing services solely over the internet is subject to the ADA's prohibition against discrimination on the basis of disability. So it seems to be a strong indication. And they also reached a settlement agreement with Peapod a number of years ago, which is an online-only grocery business. So it would be odd for them to reach a settlement agreement with Peapod and then turn around and say, well, but Peapod's not actually covered. So hopefully we'll get some more formal guidance on this through the regulations. But as a practical matter for businesses, it kind of doesn't matter, right? I'm not a tech person, but my understanding is no one's designing a website solely for use in California, but not in New York, and you're not sending out different versions of websites to different states. So this is a map of the U.S. showing the color lines represent the virtual connections from networks to the backbones of where the websites are coming from, and everything is so interconnected that I think for most businesses it just makes sense to make sure their websites are accessible. All right, Section 504. Oh man, I'm going to try to speed up a little bit because I see we only have about 10 minutes left. I can't believe it. So Section 504 applies to entities receiving federal financial assistance. And it kind of has a lot of the same obligations as Title II. It covers all the operations of the entity receiving federal financial assistance, not just kind of the limited program they're receiving the federal grant in. 508 covers federal agencies' own IT, governs what they procure, what they operate. It would apply to both what employees inside of an agency are using, in addition to what the public is getting from the agency, so what's on their websites, for example. It can apply again, through contracts. Often federal government, if they're contracting with a private entity for something, will include the 508 requirements. So private entities can be on the hook through contractual obligations, but the government remains on the hook as well. Here there are technical guidelines issued by the Access Board, and they made clear a couple years ago that websites do have to comply with WCAG 2.0 AA. And there is an undue burden defense, but for federal agencies, I think it's very hard to meet given the size of the federal government, that something would be too costly. Next up is the Affordable Care Act, Section 1557. Yes?
Again, my name is Amy Cole. The feds only have to comply to WCAG 2.0, and the states are now having to comply with 2.1, just to be clear that that's a difference.
It is a difference, yeah. And I'll note that the Title II regs note, the 2.1 is a floor for now. And so, the same is true for the federal government. But yeah, that is a difference. Yeah.
Marie asked, for places of public accommodation in physical location, do they only look at the retail location where customers go, or would a corporate office count?
Good question. My sense is that it's generally the retail location, because I think most of the online businesses do have a corporate office, but they're not considered the place that the public is going. If the public isn't going into them to access the service, then it wouldn't count as kind of that brick and mortar store. So the Affordable Care Act, Section 1557, applies to recipients of HHS, Department of Health and Human Services funding, so any entity that gets Medicare, Medicaid money, and it requires equally effective communication. I won't get into the False Claims Act for the sake of time. The new thing here is that HHS just issued its final rule under Section 1557. It was published last week, becomes effective July 5th, and it basically restores some aspects of the 2016 rule rescinded during the Trump administration in 2020. But two exciting notes for this group is that it explicitly has portions that pertain to telehealth and AI. So it notes that telehealth platforms have to be accessible, and doesn't ban the use of AI, but it talks about how entities are starting to use AI with medical decision making, and that the end result can't be discriminatory. So if entities are using AI, they need to be really cautious thinking about how disability discrimination might be baked into it. Also expands some of the covered entities. Sorry, I'm kind of racing through at this point. And then the Air Carrier Access Act, there's no private right of action here, so you can't file a lawsuit. You can file a complaint with the Department of Transportation, but it talks about, it governs airline websites, it governs kiosks, 25% are now needing to be accessible. The federal government, in addition to putting out regulations, also puts out guidance documents. So some recent ones are listed here. There was a joint DOJ EEOC guidance on basically AI in hiring. Again, not banning the use of it, but cautioning employers to be aware of problems that can arise. Sometimes there's screening that AI does that end up screening for disability. So, for example, speech issues can be picked up as in AI as a problem. So entities that are using AI also need to be prepared to offer different tools for hiring or assessing folks that if their AI has some problematic features like that. Guidance recently on telehealth, again, kind of emphasizing the importance of making sure telehealth platforms are accessible. Excuse me, last year there was a Dear Colleague letter from the DOJ and Department of Ed on post-secondary online accessibility, covering making sure post-secondary institutions were on notice that, content, learning content platforms needed to be accessible, things like Canvas, et cetera. Also that if they're putting up videos on YouTube or something, or podcasts of lectures, or allowing folks in the university to put these up, they need to be accessible. So they need to think about captioning, sign language interpretation, et cetera. And this was, I think, largely a follow-up from the DOJ settlement with the University of California, Berkeley, which an issue there was a lot of the inaccessibility of a lot of videos that the school had up. So this was kind of putting other schools on notice to be thinking about it and making sure things are accessible now. And then there's recent EEOC guidance on visual disabilities in the workplace, making sure that employers are on notice they might need to offer reasonable accommodations to deal with AI that might have a discriminatory impact.
Hi, my name is Misty Lenhart. I do have a question about when we talk about Canvas and classroom documentation and resources. What is the general guidance with providing supplementary links to external sites, not specifically tied to a specific assignment?
Mm-hmm. Yeah. I think we'll see how it plays out. I mean, I would argue it's a sort of third-party if it's something that the instructor is saying students should look at and read, they need to make sure it's accessible because it's a third-party, it's kind of third-party content that they're controlling, right? They have a choice of whether to put that link on their website or not. So I think that will, yeah, if it's optional, I mean, I would argue under Title II, I mean, students with disabilities need to have access to optional readings too. It could though be, I mean, so certainly a professor can put a textbook on the syllabus that's not natively accessible, and then the school is under an obligation to provide the accessible version. So that might be an instance where if there's a website that's inaccessible, it might not be a problem to list it, but the school needs to be ready to provide all the content on that website to the student accessibly. So they might talk to instructors and say, you know, be careful about your posting, or what do you need to, what are you hoping the students get from this? What other format can we put it in? That's a great question. I'm just going to breeze through. There's state laws that apply for the sake of time, and sometimes they can be more stringent than federal law, so it's good to be aware of that. I'm going to breeze through the international laws. There are international laws that apply in this space. And I'll just put a plug in. I'm sure all of you know Lainey Feingold. She's amazing. On her website, she has a nice listing of a lot of international laws governing digital accessibility, so I'd refer you there. Laws and regulations on the horizon. There's a Website and Software Applications Accessibility Act, making extremely clear that the ADA covers websites and apps, including standalone ones. It also kind of dives more into what accessible means with this kind of functional definition that largely mirrors what's in WCAG, perceivable, operable, understandable, etc. That's been introduced again. My understanding is it's in committee. I don't know how much movement is expected. One other interesting note about this bill is that it covers developers of websites and apps, and those folks have been hard to reach under existing law. So that's a big deal. The Communications, Video, and Technology Accessibility Act, it's currently in committee. It kind of builds on the existing 21st Century Communication Video Accessibility Act, expands requirements and standards for captioning, audio description, and requires entities that kind of offer user-generated video to offer tools for captioning and audio description. So that would be a big improvement. The Department of Ed has said that they intend to start a rulemaking process to update the Section 504 regulations. That was announced in May 2022, but there have been no updates. So that's an area to look out for. Kiosks, there has been an advance notice of proposed rulemaking by the Access Board for regulations governing kiosks, but we are still waiting for that. They thought they would have it out by the end of 2023, but here we are in May and 2024, and we still don't have it, but something to look out for. And the FCC has put out a notice of proposed rulemaking with the goal of improving video conferencing accessibility, so things like Zoom, requiring the provision of captioning, text-to-speech, enabling the use of sign language interpreting. The comments for that closed in October, so any day we should get kind of, you know, the final rule, I would think, but it can take a long time, as you all know. So case updates, I see we have a minute left. I don't know if there's any wiggle room to go over or if I should. Okay, all right, great. So some Title III updates, not really any changes in terms of which circuits are considering standalone websites covered, but there has been some change in California state law. There was a hope that the California state law, the Unruh Act, might be interpreted to cover standalone websites because California is in the Ninth Circuit where they're not covered. Unfortunately, these two cases, the Intermediate Court of Appeals has shut that down. The Supreme Court, the highest court in California, has refused to take these cases up. So It's possible one day they might take the case and reverse course, but it's not looking good. Title II, some updates, just kind of pointing out some recent DOJ settlement agreements. The Service Oklahoma one is notable because that is a mobile app. So it's, I think, cool to see the DOJ acting in a mobile app only space. This is a mobile app that people can put their driver's license on, and it requires Service Oklahoma to make their mobile app compliant with WCAG 2.1 AA, and they actually only get 6 months to do it, so not 2 or 3 years. So that's another example of the DOJ requiring a tighter timeline than you might believe exists under the regs. City of Virginia Beach, this is the one I talked about earlier. This settled in April 2024 after the Title II regs came out, and again required fixing the website within 18 months. And the DOJ in November issued letters of findings that various counties in Texas, their websites regarding voting were inaccessible. So after a letter of finding, assuming the entity wants to negotiate, we might see a settlement agreement there, and that might provide kind of more breadcrumbs on the kind of the timing that the DOJ will require for entities to fix their websites. Yes.
My question is around, do you believe that there will be an increase of proliferation, perhaps, in Title II litigation?
That's a good question. I'm not sure. There's a lot of obstacles to civil rights litigation generally that the courts have put up, beyond just sort of what's happening textually in the statute. But and it's also the case that websites have been covered for some time. So my hope is no. My hope is that entities will see the writing on the wall. I mean, literally, like, the regulation is out. There's no question what they have to do with their websites and mobile apps, and that they will voluntarily comply. So my hope is no. Education, there have been a number of settlement agreements covering, and the second one here is the one with California Berkeley, the 2022 consent decree with DOJ, covering free online content. So this is a space I think a lot of universities weren't paying attention to, just kind of putting up lots of stuff and not checking that their videos were captioned, et cetera. And between that settlement and the recent DOJ Dear Colleague letter, I think we'll see some change. I hope we'll see some changes there where universities are paying attention to that sort of content they're putting up. Another big one was the CUNY settlement with the DOJ in 2023. It was there was an individual blind student, so there was individual relief for him, but there was also systemic changes required. And CUNY is a really large school system in New York, so should have widespread changes. And as I mentioned, there's the case that I've been involved in against the Los Angeles Community College District. We won. We had a trial last spring. We have 2 blind former students. And there have been a lot of things happening since then. I won't get into everything. A lot of it involves damages and Supreme Court case law that's sort of changed damages. So there will be an appeal. LICCD has also moved for basically the court to kind of strike a bunch of the jury's findings about things violating Title II, arguing that having inaccessible course materials didn't deprive the students of meaningful access. They're wrong, and I'm optimistic the court will shoot it down, but there's more to come in that case, so be on the lookout. The employment setting, one notable 508 development, a really exciting one actually. In February 2023, the DC Circuit held that Section 508, which again covers federal government internal IT, does have a private right of action. So an aggrieved federal employee can actually sue under that law in court to have 508 enforced, which is what happened here. Other things to be on the lookout in the employment space, customer service technology remains an issue. AI in the workplace, obviously a huge issue and will become more of an issue. So, and we can see the EEOC is starting to kind of gear up and issue guidance around that. So I'm sure we'll see more to come in that space as well. Kiosks is an area I think we'll be seeing more about. One notable thing, Social Security Administration, this was something I was involved in. There was a court-ordered settlement agreement for them to replace all of their kiosks, their check-in kiosks in their field offices with accessible ones. That finally happened at the end of March, so all the field offices now have accessible kiosks. And actually, just an example, I'll just note, when they designed their kiosks, the ones that they just replaced, they argued they were technically 508 compliant, that they had thought about 508 and they had done it right. but they did no usability testing. And so they had all these features in place, and they finally did the testing, and like, it did 10 blind users, and none of them could figure out how to work anything. So it's just, one of the things we required in our agreement was that they take into account usability, so that you're not designing something with a lot of great features that no one can get to. Other developments, the Quest Diagnostics and LabCorp cases are moving ahead. Quest Diagnostics, actually, well, it's not, there was a bench trial. The judge issued an order requiring Quest to add accessibility features to the previously inaccessible self-service kiosks, holding that waiting for someone, from a staff member to come around and help you is not what's required under the law. And I'll just note, a press release hasn't gone out yet, but it will soon. It is public. CVS, in their Minute clinics, use these self-checking kiosks that are inaccessible. And we just through structured negotiations, reached agreement with CVS. They'll be replacing all of those over the next 18 months for accessible tablets, probably, or some other kind of accessible solution. Entertainment, I'll just highlight, there are these cases in the virtual reality space, and they're moving ahead, and so that's exciting and something to watch out for. And as I mentioned, one of the pending legislation, one of the bills, explicitly kind of reaches virtual reality and what's required. Overlays, I'll just point out this Lighthouse for the Blind case that settled in October 2021 around payroll processing HR company. They tried to use an overlay for accessibility. Shocker for this crowd, it didn't work. The settlement requires accessibility fixes and actually explicitly prohibited the use of overlays. SLAP suits, so those are suits, lawsuits against the public participation, meant to suppress people from participating in public and saying what's, advocating for positions. That continues to be something to look out for, and we have someone here who can probably speak more to it, Adrian Rosselli, and he was the subject of one that fortunately settled in January, but something, unfortunately, we might see more of. One other exciting development under the False Claims Act. So this is a law, and states have them too, that allows individuals to kind of blow the whistle and say, hey, government, you contracted for this thing and you were ripped off. This vendor didn't do what they said they were going to do, and nobody else really knows about it, but I have inside knowledge and I know, and I'm going to tip you off and you can go after them. So that's what happened here in California. The state of California paid $66 million for a vendor to create a brand new online park reservation system. And part of the contract was you need to make it accessible, and it was not accessible. So there was a blind whistleblower, and Tim Elder, who's a wonderful attorney, a blind attorney out in California, worked on this case. And after some good rulings by the court, it eventually settled. The developer agreed to pay $2.05 million and fix the system. So this is a new avenue I think we might be seeing more of, people kind of helping states go after vendors who promise them basically a false bill of goods. And then tester standing is a huge issue. A lot of us were following the Laufer versus Akeson Hotels case, which involved whether someone who went on a website just for the purposes of seeing whether it was accessible could have standing, could have the right to bring a lawsuit against them, whether they really suffered an injury that you need to be able to bring a lawsuit. And it went all the way to the Supreme Court. Disability rights advocates tried to keep it out. Weird things happened, basically, where the plaintiff ended up dropping the lawsuit or trying to drop it because her attorney was mired in ethical issues and just kind of tried to bow out. Everyone argued, Supreme Court, you don't have to hear this case anymore. It's moot. She dropped her case. They still wanted to hear it, so there was oral argument. But luckily, following the oral argument, they were like, okay, we agree. This case is moot. There's nothing to decide because she dismissed her case. But it's something to watch out for. Folks in the disability rights community are rightfully, I think, panicky about the Supreme Court touching this issue. And it's not just disability rights. I'll note that people in the fair housing space, for example, submitted an amicus brief in this case because if there is no standing, if a tester can't bring a lawsuit in this instance, it calls into question a lot of the case law under the Fair Housing Act around fair housing organizations sending in testers, right, to see if people landlords are discriminatory, for example, and other lines of case law as well, where tester standing has long been established. So this is an example, I think, of the broader civil rights community kind of banding together to try to keep this out of the Supreme Court, and if it gets to the Supreme Court, trying to really link arms to show the court what a drastic change this would be, but it's something to look out for. I have a whole section on best practices for compliance. I think I will probably cut that for the sake of time, and if anyone has any other questions, but I will put in a plug. My firm, I'm mainly a litigator, but we do have a consulting arm, Inclusivity Strategic Consulting. My colleague Eve Hill really runs that. We work with organizations on best practices for complying as an organization to ensure accessible websites and mobile apps and all of that and more. So happy to have you reach out. And I'm sorry about my time management this session, but I'm glad we had so many questions. And if you have more questions, I'm happy to stay and chat. But thank you so much.